Is a will enough? Sometimes I have people come in the office and they say, all I want is a will. So let's talk about what a will is, when it works, how it works, and then you can answer for yourself if a will is enough for your particular situation. So a will is a last will and testament, we all know, a document that says when I die, I appoint these people as my executors and this is the distribution I want. Let's talk about when is that will used. There are two main reasons, usually there may be a few more, but two main reasons why probate is needed. Probate means you have to go through the court process when someone dies. If a probate is needed, that's when the will comes in handy. Number one is a house or real property. That's one of the reasons why probate is needed. If you own a home, land, or mineral interests. And we're not going to talk about why that is. If you want to know more, be sure to watch our other educational videos. But if you own real property, that's when probate is needed, and that's when the will be used. And two is financial accounts without beneficiaries. Again, we have lots and lots of videos on this topic. Basically, if you have, let's say, a life insurance, and you don't have beneficiaries listed, or they predeceased you, or let's say you have a bank account over a certain amount and you don't have a payable on death on that bank account, they're not going to know who to pay, and they're going to say you go through the court process, and again, that's when you use the will. So is the will enough? It depends on your situation and on your wishes and goals and plans for the future. If you are okay with your family going through the probate process, if you have a home or if you have a financial account without beneficiaries, then a will may be okay. At least you are the person who picks who should be in charge and you can designate a distribution. Oftentimes people try to avoid probate, so a will may not be enough. Probate is expensive, it's a public process, you have to deal with creditors, it can be a mess. So if you're trying to stay out of courts and you have real property, your home, land, mineral interest, a will may not be enough. Make sure the other side, the financial assets, is easy to fix. So make sure you check all of your financial assets and make sure you have beneficiaries listed, not just primary, but also secondary. If you don't have real property and you have beneficiaries on everything, a will likely not have to be used. It's always a good idea to have one just in case you forgot about something or you inherit something at the last minute and you are incapacitated, for example, and you cannot designate a beneficiary. It's good to have a will, even more so if the distribution that you want in your will does not match what the default is. When you don't have a will, there is a default. The law dictates who gets what, especially, for example, if you want to disinherit a child, or if you have a child with special needs and you want to make sure that their money gets protected, or if you want to include a neighbor, a friend, grandkids, and so on, then absolutely you should get at least a will. Even though they have to go through probate, you should be the one who decides who gets what. I hope this helped. Again, this video will send you to the other videos that we have, but a will sometimes is enough, a will sometimes is not enough. So I hope this video made it a little more clear. Please, please, please email me if you have any questions or topics for future videos. I would also encourage you, if you are local, to attend one of our in-person educational events. Those are great opportunities to ask questions, to learn more about how a will works, what's the difference between no will, a will, and a trust, and so on. Thank you for watching.